I really appreciate the attendance. We almost have a full room, and I really, after all the Zooming and not seeing people in person, I'm really glad so many people came. I know it's a Monday, and I wasn't sure. This is the first time we did it on Monday, but since the faculty meetings weren't on Monday, they asked us to do this to try to avoid conflicts. It turns out there is a faculty meeting today on a Monday, but that's a different story. But I'm really glad the students turned out. I also want to give a hand, and please join me, to Claudia Delgado, who's responsible for the logistics and the lunch, and Professor Barbara Laureate, our Marks IP fellow, who arranged all this, coordinated, make sure the professor gets here. We had a nice dinner last night, so let's thank them for this. Doesn't happen by accident. And it's really a pleasure. And you sit for a second, because I don't want to. It's really a pleasure, and I'm proud to introduce our speaker, because I know her, and I don't even have to look at her CV. Well, I will probably look at her CV, but because she graduated from GW in 2011, and we were reminiscing last night that we met in Munich when she came to Munich and took our class. That's a different issue. We are working on it. Please don't badger us, but we're working on trying. It's hard to get it up and running again, and we're probably going to do it. But we have a call this week, and we're trying to create classes. So we should have some announcements by the end of this month, before registration. And you want to talk to somebody who came to Munich? She did, and I think she enjoyed it very much. But Krista was a student at GW just like you. And I'm going to embarrass a little bit because we talked about this last night, but her senior year, her third year in the spring, she didn't have a job. And it was because of some unfortunate circumstances. The firm she worked at merged or went belly up, and so her offer was rescinded. And it wasn't because of her talent, because she had excelled in law school. She graduated with honors from GW. She was a research assistant to Larry Cunningham, who's a real big supporter. She wrote papers for Marty Edelman, who's a real big supporter. And she comes to my office and she doesn't have a job, and we talked about it. And just like I said, this lunch doesn't happen by accident. Where she is today does not happen. She wound up working for two of the best law firms in the country, in Kirkland and Ellis and WilmerHale. She had huge supporters there. She did a lot of different areas of IP. She's a patent person, but she did a lot of interesting areas and really got into advertising law. I remember we were talking about. And she has a family, but she wanted to be a professor. And, not everyone who graduates from GW becomes a law professor. It's a hard job to get. There's not that many of them. Figure every school's got one or two IP people. You add it up, there's 300 jobs. And she was persistent. She marched to her own drum. She had family responsibilities. We would talk about once a year, once every 6 months. She came to some of these talks. She would come up to the speakers and meet them and ask for advice. And she is now a professor, tenure track professor at Cleveland Marshall College of Law in Cleveland, Ohio. So if you want to talk to someone about how you can graduate from GW and become a law professor, she is a great person to talk to. I'm sure she'll be very supportive. And it's not easy, but it can be done. And she's a role model that we can share with everybody. As I said, she graduated with honors. She's the world champion in a space law competition. Not many people can say they were the world champion of something. And she was a note setter of the AICLA Quarterly Journal. She's a graduate of Arizona State with a bachelor's of science in biochemistry and a minor in German. Maybe that's why you came to Munich. She's published several articles in the Miami Law Review, the AICLA Quarterly Journal, her alma mater, the Florida Law Review, and the Chicago-Kent Technical Law Review. And her paper is on maybe rethinking the jurisdiction of the Federal Circuit. I'm not going to ask you whether or not you sent this to the judges on the Federal Circuit, but we can get into that when her paper is done. And please give a warm welcome to Professor Krista Glaser.
All right, thank you all so much for coming. It's great to see such a wonderful turnout from all the students at the place where I went to law school. I remember these talks being so important for me as a law student to help understand all the different nuances in intellectual property law that were happening outside the scope of what you learn in the classroom. It's rare that you get the chance to see everything happening on the cutting edge in a way that's far beyond the scope of a textbook. So I appreciate you all coming. I think these are good. You're going to look back on this and find these experiences of coming to talks like this valuable. I know I did. So my paper today is Rethinking Patent Law's Exclusive Appellate Jurisdiction. I think that law should live a little before it's frozen in time. This didn't used to be a controversial position. Many years ago, before the creation of the Federal Circuit, which is the appellate court that handles patent appeals, in most areas of law, the law would percolate through from original decisions in the district courts to regional circuit courts of appeal, and then to the Supreme Court. It's only now that the Federal Circuit for the last 40 years has been deciding all patent appeals that originate from the district courts, in addition to administrative appeals from things like the Patent and Trademark Office, the International Trade Commission, and a couple of other administrative sources. I propose that we should go back to a system where law can percolate in patent law. We should reform the Federal Circuit's jurisdiction to return district court appeals to the regional circuit courts while maintaining the Federal Circuit for deciding patent appeals. And we should adopt what's called the Haruska Commission's National Court of Appeals. And I'll talk more about what that is later and the scope of it with some modifications. So why do I reach this conclusion? The ideal judicial system is one that comes from a diverse set of opinions with groups of people that have different ideas, different experiences, all contributing to the development of law. One where some judges are experts and some judges are generalists, where some judges come from large amounts of practice experience and some come from perhaps more historical perspectives. We know from the consulting industry and various other areas where they've done research on the value of diversity of opinions, that diverse opinions and diverse inputs lead to better outputs. So why aren't we doing that when it comes to patent law? Another component of an ideal judicial system is one where there's independent percolation of those ideas. Right now, with the Federal Circuit, you might have some new ideas that emerge in the various district courts. But when they come to the Federal Circuit reaches a decision and knocks out the possibility for future experimentation of that law. Before the creation of the Federal Circuit, you could have a decision from a district court that would get appealed to a regional circuit in one location with one set of ideas. That regional circuit could decide, is that law right or wrong? They might develop a rule. That rule might broadly cover very different factual scenarios. As the district courts would continue to decide those issues, they would show the merits of that particular rule. They would show how that rule could apply in different contexts. But we don't necessarily have that when it comes to the Federal Circuit, when you only have one place for appellate law to emerge. And then the last component that I believe we should have in an ideal judicial system is that we ultimately have a consolidation decision, that all those different ideas come together with some court or perhaps some other body finding that the law should be this way or that way. They choose from among the various different approaches that all of the other courts have articulated. There's a consolidation decision. This is important because certainty of law is very valuable to business interests. And this idea, the value of certainty, is what prompted the creation of the Federal Circuit many years ago. Before the creation of the Federal Circuit, there was concern that when law percolated throughout all these different regional circuits, that there was so many differences in patent law, this critical national property right, that people could not anticipate what might happen with their inventions. People could not anticipate whether they had freedom to operate because so many different courts would have different opinions on the scope of that law. This created a problem when the Supreme Court was not taking very many patent cases. You had percolation, but you lacked a cohesion decision. The Supreme Court at the time of the Federal Circuit's creation in 1982 was hearing 1/3 of the patent cases that it was, 1/3 of the patent cases that it was hearing today, and taking on many more additional cases in other areas of law. They had a much larger docket than they do now. And so as a percentage of their docket, the Supreme Court was hearing very few patent cases. And this resulted in a lot of confusion. There was no certainty around what the scope of your patent might be or how it would apply to others' inventions. The Hruska Commission in the 1970s originally started studying this problem of the Supreme Court lacking the capacity to issue nationally uniform decisions in all areas of law. They noted a particular concern in patent law because this is an area where, as I noted, there's a critical need for uniformity, a critical need for business to know what's going to happen with their patent. But it applied everywhere. The Supreme Court's failure to decide inter-circuit conflicts was creating problems in many other areas of law as well. Areas like environmental law, tax law, immigration law, places where you also want national uniformity of law. You don't want tax law to be interpreted differently in the Ninth Circuit and the Fifth Circuit, for example. So the Hruska Commission, after studying the problem of the lack of the Supreme Court's capacity over many years, made a recommendation. They recommended creation of a National Court of Appeals. This Court of Appeals would sit between the regional circuit courts and the Supreme Court. And it would hear cases that were either referred to it by the Supreme Court or referred to it by the various regional courts. And it would be staffed by judges that would be sitting from other circuits. So for example, a senior judge from the Second Circuit could come and sit on the National Court of Appeals, and they would be helping the Supreme Court to make these consolidation decisions, to decide cases in a way that would be nationally uniform before the Supreme Court had the chance to, or if the Supreme Court lacked the interest to address the case. This proposal was met with bipartisan support, both in the political realm and at the Supreme Court and the ABA. Pretty much all organizations supported the creation of this National Court of Appeals, except the appellate court judges.
You'd have to serve on the court.
Exactly. The appellate court judges were not excited about the other judges on courts sitting above them and judging their decisions. Their fellow judges would come and judge them and overturn their decisions. They were not happy about that possibility. But other than that group, for the most part, this was met with bipartisan, widespread support. So why didn't it get adopted? Well, you can have a good idea and have an idea that everybody supports, but lack the political power to get it implemented.
Congress.
And so many times, despite having an idea with widespread support, it doesn't get passed. And this happened with the proposal for the National Court of Appeals. Had widespread support, but there was insufficient political will to get it passed, especially when there were some judges on the Court of Appeals that opposed this system. And now I should add that they even proposed some alternative approaches when these actually came to be developed as bills in Congress. They proposed some alternatives where instead of getting referral jurisdiction from the other regional circuits, it would just be cases that the Supreme Court sent down to them. That was more acceptable to many of the regional circuit courts. But I think the judges on the regional circuit courts also believe that this would create a little bit of an administrative problem as well. So this Hruska Commission proposal failed. After a few more years, we had a confluence of political events that allowed a different system to pass. We had reports from the Carter and the Reagan administration showing concern, particularly in patent law, that the lack of nationally uniform binding decisions in patent law was creating a problem for the US's national reputation international reputation for innovation. That it was making it difficult for US companies to assess the scope of their rights and innovations and provide predictability that would allow them to compete on the international marketplace. And there was a belief that perhaps if we could get more nationally uniform decisions in patent law, that we can improve the US's competitive position in innovation. So we have the presidential administration, multiple presidential administrations having this concern, particularly around patent law. And at the same time, we also have a professor that came in with a passion for trying to solve this problem. So Professor Meador came in and proposed another alternative. Instead of having another tier of courts, Professor Meador proposed a specialized court, one that would siphon off the district court appeals in multiple areas of law. Originally, the proposal was simply for a court that would address tax, environmental law, and issues of science. Now, because you have this political will over here focused only on patents, ultimately that proposal got whittled away. Environmental law fell off the map, tax law fell off the map, and what was left was a proposal for a court focused on patents. Now, there's a concern when you have specialized courts. When you have a specialized court system that focuses only on one area of law, there's a concern that you get captured by members of that industry. There's a concern that the court can become insular, and that by lacking diversity of ideas from other disciplines, that they won't be able to make high quality decisions. So what did Congress do to try to address this concern? Well, they added additional things as a bit of a grab bag into the Federal Circuit's jurisdiction. They added veterans' appeals and some other administrative appeals to try to make the jurisdiction of the Federal Circuit more balanced, to try to make it so that it was not predominantly a patent court and only a patent court. And we'll see when we get to some of the changes that happened that prompted my proposal for change, that the Federal Circuit is no longer a court that is not a patent court. It is definitely a patent court now. So when the Federal Circuit was created, they received a mandate. The judges on the Federal Circuit received a mandate that their job was to make sure that patent law was going to be nationally uniform and clear and allow people to predict what their rights would be. This caused the Federal Circuit to have a certain ethos that's different from the ethos of many other regional circuit courts. They tend to be very focused on providing clear, bright line rules. And this is something that folks that have studied patent law might have seen. There's a bit of a conflict that ends up arising when you have a specialty court like this that perceives a mandate to provide clear, rule-based laws, and you have a Supreme Court that doesn't have that mandate. That can create conflict. It wasn't a problem when the Federal Circuit was created because the Supreme Court wasn't really involved in patent law then. Part of the reason we needed the Federal Circuit at the time is because the Supreme Court wasn't stepping in to perform that unifying function. The Supreme Court wasn't really involved in the conversation at that time. But times have changed. This chart is from one of my previous papers focusing on certiorari at the Supreme Court in patent cases. But the number of the Supreme Court patent cases have increased dramatically since the time that the Federal Circuit was created. So we see in the 1980s timeframe, when the Federal Circuit was created, the Supreme Court heard 7 cases that entire decade. That's less than 1 case a year on patent law. Now, in the 2010 to 2019 timeframe, we've had 34 patent cases. the Supreme Court has become highly involved in patent law. Now, granted, this might not always be the case. This might be changing. We don't know for sure yet. With ideological changes to the court, that can change what types of cases they pick up. And there's some evidence that when you have an ideological court, they might be more likely, an ideologically divided court might be more likely to accept cases like patent law that they perceive to be ideologically neutral. So this might change, but right now, the Supreme Court is highly active in patent law. And how does that affect the certainty of law? Well, you can imagine that if one goal for the Federal Circuit was to create certain national uniform law that everyone could rely on to predict the scope of their rights, and then you have the Federal Circuit getting second guessed by the Supreme Court repeatedly, more than a few times a year, that can change the level of certainty that players in the marketplace have. And furthermore, where's the Supreme Court getting the ideas for the rules that it ends up implementing? Well, it doesn't have a bunch of regional circuit courts to choose from. All of the ideas for what rule to adopt coming from the Federal Circuit and the briefs leading into those decisions. They don't have a second court that's trying to make a neutral decision about what the best scope of law should be. The Supreme Court doesn't really have as much information to draw from to create those rules as it might have if you had multiple regional circuit courts deciding these issues, and especially if the Supreme Court had the information from the percolation of law. Imagine how much better the law could be if the Supreme Court could look at each rule in every regional jurisdiction and then look at how the district courts underneath it had applied that rule, how that had affected the facts of those underlying cases. That information could help the Supreme Court make better decisions. And we know from research in many other areas of law that when you have more information, to a limited extent, this can go too far, but generally when you have multiple pieces of information to draw from in making a decision, especially if they come from diverse sources, that can improve the quality of your decision making. So this is something that we understand and apply in every other area of law outside of patent law. But in patent law, because of the Federal Circuit, we have a different system, and the Supreme Court's not getting that information. This also creates problems for stakeholders in the patent community because they also can't make good predictions about when the Supreme Court is going to overturn a Federal Circuit decision and what rule the Supreme Court is going to come up with. Typically, the Supreme Court in every other area of law bases its determination of whether to take a civil case on whether there's an intolerable circuit split. You have two regional circuits that came up with a very different rule on an important issue. You don't have anything to guide that decision in the patent space. Some people might say, well, you can use different panel decisions or the vigorousness of the dissent of an en banc to try to make those determinations. But the Supreme Court doesn't take those quite as seriously as circuit splits. They lack the information to make a determination of when they're going to grant cert. So there can appear to be some sort of randomness in the types of cases that the Supreme Court takes up in patent law that doesn't necessarily apply in other areas of law. Now, what else has changed? We talked about how if you have a specialist court, there's some risk of capture, there's risk of insularity, there's risk of ossification of the law. You have an echo chamber. So what did they do when they were creating the Federal Circuit to try to avoid this echo chamber? They added other areas of law to the scope of the Federal Circuit's jurisdiction. Well, the scope of the Federal Circuit's jurisdiction has changed dramatically in the last 10 years. In 2009, patent cases, both from district courts and from patent appeals from the administrative cases, were only about 34% of the Federal Circuit's docket. With the passage of the America Invents Act, we now have far more appeals coming from the Patent Office. Why is that? They created something called inter partes review. I see some folks nodding their heads. It sounds like a lot of people are aware of this, but some aren't. Inter partes review is where you can look at a patent that's issued and challenge its validity through an administrative procedure at the Patent Office. Oftentimes, whenever somebody is sued for infringement of a patent, they'll go and bring a claim to invalidate that patent at the Patent Office. It's a separate proceeding focusing only on invalidity and only on certain types of invalidity for most of those proceedings. Since that process was expanded, we've had far more administrative patent appeals. And in fact, in 2018, patent cases, because of that, became 2/3 of the Federal Circuit's docket. Can you say that the Federal Circuit is not a patent court if 2/3 of its docket is patent cases? No. They're going to have insularity. They're going to lack the diversity of thought, the diversity of ideas that they might otherwise have with a more diverse docket. The Federal Circuit no longer has the safeguard that was put in place to prevent the problems from a court of specialized jurisdiction. This brings us back to my proposal. If we were to take the district court appeals and put them back into the jurisdiction of the regional circuits, we would have some diversity of thought in patent law. The Federal Circuit could continue to hear cases that were administrative appeals from the Patent Office. But when you take those district court opinions away, patent cases would no longer be a majority of the Federal Circuit's docket. It would start to have a little bit of that diversity of thought that it had before. And yet you still get the benefit that the Federal Circuit would be issuing decisions that are very different from the regional circuit potentially, or at least influenced by a different set of judges with different backgrounds. The Federal Circuit tends to have judges that have technical expertise, that have a lot of knowledge with patents. And this is not the case for the judges that are at other regional circuits or even the Supreme Court. The Supreme Court has not had any judges that have technical expertise in the recent past, and they fail to have clerks with technical expertise for the most part as well. It's very rare for them to have clerks that have technical expertise or patent law expertise. So you would at least have some diversity of thought if you maintain this. You'd have some patent cases getting decided by generalist judges, judges that have experience in other areas of civil law, perhaps hearing contract cases or antitrust cases. And then you would also have some decisions from the Federal Circuit, from courts with technical expertise, a court with technical expertise, and judges that are trained with patent law and experienced with patent law. But then we run into some of the problems that we had that prompted the creation of the Federal Circuit if we just stop there. If we stop there, we come back to the uniformity problem. How do we get uniform law in patent law and other areas of law where it's important to have nationally uniform decisions? Well, we could say the Supreme Court is perhaps stepping back up. They're deciding a lot of decisions in patent law. Maybe they'll keep that up. But even having 5% of its docket as patent cases, as it does now, that's not necessarily enough to resolve every single important conflict that might arise in this area. You might end up in the same place that you ended up before. So what's a potential alternative? The alternative to specialized courts is an extra tier of courts to try to say, well, let's find another way to give uniformity. So I propose adopting a modified version of the Hruska Commission's National Court of Appeals. It would sit between the regional circuit courts and the Supreme Court. It would hear cases that the Supreme Court refers to it. In my version of the proposal, it would not have reference jurisdiction from the regional courts, because I think that could create a lot of conflict where litigants would fight about whether there should be reference jurisdiction or not in that particular case. Let's just let the Supreme Court decide that. And then how do you address the problem of the Supreme Court's caseload with having to make a bunch of certiorari decisions? Well, they already have to make those certiorari decisions. Now they would just have an output to direct some of those ones that they don't feel that they have the capacity to take. They would still be making the same amount of certiorari decisions that they make today, but they would have a way to offload some amount of those that they don't feel that they have the interest to address. And those decisions from the National Court of Appeals would be subject to review by the Supreme Court. Presumably, you could also staff the National Court of Appeals with judges that have some amount of additional expertise in complex areas of law. So perhaps you have a judge that has a patent background or a technical background. Perhaps you have a judge that has a tax background or an immigration background or an environmental law background. You can again have some amount of diverse expertise that perhaps differs from the expertise that the Supreme Court has. The Supreme Court might choose in that instance to refer cases that are technically complex and take cases that, for example, address civil rights issues or other issues that are particularly important to the Supreme Court at the time. If you have a system like this, you avoid the insularity of the Federal Circuit, you have more diversity of ideas, and then you also get a cohesion decision faster than the Supreme Court can actually address it. So I'll leave it there and open it up for questions. Thank you all for coming.
So will that Professor Laureate run the pick who's next up to speak or ask a question? We also have about a dozen to 15 people in the on Zoom, and so I think what she'll do is take one from the room and Zoom will alternate, as I've seen her do in the past. May I ask the first question? I think if you showed this proposal to the current Federal Circuit, they quit.
Yes.
Because there is at least some quiet backstory that they don't like all the PTAB cases, and a friend of mine has referred to them now, the way their jurisdiction is, as they've returned to the CCPA, the Court of Customs and Patent Appeals, which was one of the two predecessor courts that merged with the Court of Federal Claim, with the Claims Court, and they only heard PTAB cases and CIT case or whatever. So you basically be turning them back to where they were,
Right.
Which they wouldn't like substantively, I'm sure. But the other question I really had, so you may want to reference that in the paper. I think that would be a good comparison. Strohouse would be different. They still have some others, but and that there was nothing wrong with that court. They might not need 12 judges, but that's a different story. But are you really suggesting a solution to a problem that doesn't currently exist? And here's my problem. If you proposed this 10 years ago, 20 years ago, when the Supreme Court was getting into patent law, and they were looking at questions of damages, 103, and exhaustion stuff. Okay, maybe the Federal Circuit's run its course, and we should return it back. Is the major issue of the circuit split wasn't inconsistent law; it was bias. There was two circuits that you could get a patent valid. I think the 5th and the 6th, right? Chicago and Texas, and everybody else, because of antitrust, invalidated them. It wasn't like they was writing the law was different. It was bias. I mean, I'm going a bit far, but the statistics play that out. And maybe that doesn't exist 40 years later because we're past that, or maybe it would exist again. That was the real concern. So one, you have to guard against that. And two, I don't think the Federal Circuit, I don't think the issues they're deciding are that controversial. 2/3 of their decisions are 103. It's not like they're debating the law 103. It's just affirming PTAB cases by substantial evidence. It's not like they're debating. It's complicated. They're just applying the law again and again and again. So it just doesn't seem like there's that many district court cases anymore, and it doesn't seem like they're that controversial. And so you'd be setting up this whole new system, taking away the one area that they like. And lastly, one thing you haven't touched that you might want to address is the CVSG. How do we know which cases to get up to the Supreme Court? The Federal Circuit has been, the Supreme Court has been repeatedly asking the SG. They tell them when to take the case, when to not take the case. John Duffy has a great article. It's a little time lapse because it's 10 years ago, but it's a good article about this. And they're already doing that, and the CVSG seems to be doing a good thing. And the cases that they've taken in the last 5 years have all been PTAB cases. Because they got this new system So it's not really a question, it's a couple observations that do we really need to take away this one interesting area from them? When they're not even really debating that much, they really turned into a PTAB review.
Great questions. So I'll take them sort of one at a time. The first one that I want to talk through is this question of the original purpose of the Federal Circuit being to solve some of the bias that existed. You're right. There was a lot of forum shopping that existed at the time of the Federal Circuit's creation. And part of that is because there were differences in venue. I think some of those differences are now resolved. Of course, there's still the choice that patent owners have to resolve many different, or to take a case to many different places, but it's less than it used to be.
Right, because they want that district court, not the circuit court.
Exactly. So for those that are not familiar with some of these changes, with the TC Heartland decision of the Supreme Court, they interpreted patent venue such that patent plaintiffs could only file suit in places where the defendant had their principal place of business or where they were headquartered or incorporated. This is very different from the jurisdiction or the venue that existed before that, where they assumed that it could extend anywhere where there was personal jurisdiction. So that created a lot of avenues for forum shopping before that change occurred that I don't think necessarily exists now. And I think now you're right, people, if they're doing forum shopping, they're looking for district court that favor their procedural inclinations. So now we have, for example, some district courts in Texas that have rather plaintiff-friendly procedures like disclosures of certain things in different timelines than other courts. So plaintiffs tend to try to go to those courts. So for example, if you have to disclose prior art earlier, or if you have to disclose some places like Delaware, you might have to disclose the source of funding for your lawsuit. That draws people away from them. So there's many different choices that people make about what district court to file in. It might be something like one has a faster docket, which could put more pressure on settlement. One would allow for invalidation, time for invalidation by the PTAB, and another is so fast that it doesn't allow for that to happen. So there's many different choices that a patent plaintiff will make, but the venue changes have restricted that a little bit. So I do think that the problem of forum shopping for substantive law might be different for that reason, but also because, as you noted, the Federal Circuit has resolved many of those important decisions. We have the Federal Circuit has existed for 40 years and has resolved many of the most important substantive areas of patent law, like the scope of obviousness, and the Supreme Court has weighed in on that as well. So we no longer necessarily, I think, have that potential for the bias of forum shopping that previously existed at the time of the Federal Circuit. Now, to your question of whether the Federal Circuit's going to like this, no, they're going to hate it. This proposal will be opposed by the affected regional circuits and the Federal Circuit. But does that make that a bad outcome? No, it might not be great for them as individuals. They might not enjoy their work quite as much, but it's probably better for the quality of law. We don't necessarily need a court that singles patent law out, especially when most of their work is reviewing appeals from an administrative court. Now, perhaps what they could do is try to move some of those senior Federal Circuit judges over to the National Court of Appeals when it's established, and that might help to alleviate some of their concern. But you're right, those Federal Circuit judges really hate deciding those appeals from the patent office over and over on the same.
I wouldn't go that, but it's a single issue. It's a single issue.
Yeah, it's not as interesting as deciding these interesting novel cases from the district court. So it does change this.
You touched on this a little bit already, but there is a question in chat. Do you think your proposal would have any effect on the current forum shopping situation where a high percentage of patent cases are filed in a small number of plaintiff-friendly jurisdictions?
I think that we will still have to address the forum shopping for district court procedures. I think there's some proposals that are trying to address that. And many of the courts themselves have made changes to try to address the influx of cases that have happened. We saw some changes in the scope of judge assignment in some of the Texas courts that have distributed those patent cases away from the judges that were originally seeking those. Paul Guglielmo has an excellent paper called Judge Seeks Patent Cases or something like that. It's a very good read on what happened in Texas. But I think we'll still have those problems of people trying to
John
shop
Sanders.
Yes, with Jonas.
They co-wrote it, right?
Yes, it's a great paper.
Yeah, I
highly
mean, I think
recommended.
they got some attention
Mhm.
on this issue and
And things are starting. to
court
change.
stepped in and did it.
Things are starting to change now. So that does need to be addressed. But I think this is a proposal that focuses on the changes needed to maximize the quality of appellate law. We'll also need to do some work to change some of the procedures at the district court level to improve that type of forum shopping as well.
I think I saw your hand first. Great.
Yeah, so we talked about the sort of areas of law that desire national uniformity. You mentioned that aside from the patent law, there's environmental law, there's tax law. And I'm just thinking, if I'm a criminal defendant, or if I'm a corporation in an antitrust suit, I'm also looking at this and saying, hey, I'd like some of that national uniformity. It seems a little bit like this is something that, if you're dealing with federal law, everyone wants uniformity for all of their issues. So would the National Court of Appeals have any limits on subject matter jurisdiction, or would it just be anything the Supreme Court sees fit in their wisdom to send down to it? At that point, does it become more of like a budget Supreme Court? If it's just taking any cases the Supreme Court would rather not take and wants to send them?
I think the question for those who didn't hear was about whether the National Court of Appeals proposal would hear cases in all types of law or just in certain cases where there's need for specialized expertise or uniformity, like perhaps environmental or tax. I think that you could draft the proposal in two ways and see which one gains more political traction. I think both would be beneficial. If you have a specialized set of expertise or a limited scope of jurisdiction that the Supreme Court could refer to it, as long as it's broad enough, I think that would be fine. So if it included tax, environmental, technical cases in criminal law, such as the use of DNA evidence or other complex scientific issues, and if you included patent law, copyright law, and trademark law, I would be fine with that. I think any amount of anything where you could get both percolation of law and a nationally uniform decision is beneficial. So that structure would be fine. If that gains more political traction, I'm happy with that. My proposal would cover all areas of law and allow the Supreme Court to make that decision, which I think it would have the judgment to do, but whichever had more political willing.
Sure.
Hey, good to see you.
Yeah, two quick questions. Is this politically viable today? I mean, it seems like the big difference between the first time this was proposed today is that now the patent monetization is turning into a standalone industry with its own powerful lobby. And if you had a hard time getting uniformity of instances on it before, it would be even harder now to put it back. And the second part is, I really enjoyed your paper when you talked about like, the expertise causing bias to capture. But I was wondering if you've looked at it from a regulatory capture perspective, because unlike environmental, unlike tax, judiciary is really the regulatory body setting patent policy in our country. And when you have that frequency of interaction, you might look at the Supreme Court's decisions not as a difference of philosophy between the federal circuit, but the difference between generalists and specialists resulting in substantive outcomes. eBay, I think, is an example where it's a lot of people in the patent industry don't like the eBay decision, but when you read the eBay decision, all the Supreme Court is saying is, hey, go back to doing what we were doing before the federal circuit was created. And so I was wondering, like, if that regulatory capture and treating it like an administrative agency problem in judiciary might change your analysis.
Yeah, I do think, if I understand your question, you're saying that it's very important to consider the way that regulatory capture can affect the decisions. I think that's 100% right. And part of the reason why we need to change it. If you have more diverse inputs, more diverse types of cases that the court is deciding, it's less likely to be subject to regulatory capture, and it's more likely to lead to decisions that are coherent with the types of decisions that the generalist Supreme Court is going to issue. So I do think it's critical that if the Supreme Court and the final determining factor of what these cases are ultimately going to be is a generalist court that's going to issue broad standards, then we shouldn't have a judicial system that creates conflict by pitting a specialist court against that generalist Supreme Court. It's going to lead to conflict. It's going to lead to different decisions. It's going to lead to the Supreme Court overturning the federal circuit repeatedly, as it has. If we are committed to having generalist Supreme Court doctrine, we should be committed to having generalist appellate courts as well.
And then we have a question from.
Okay, great. So this is a terrific paper and very innovative, and I really like the way you've sort of taken the literature and debate from earlier and kind of pointed out that we need to update them based on things that have occurred. So this is really a terrific job. I'm wondering whether uniformity is really all that it's cracked up to be. And perhaps one argument that national uniformity, I mean, maybe there's a couple. Oh, well, I guess I'll start with one is that, you know, the law is not super predictable today. Certainly patentable subject matter, as far as I can tell, remains a mess. And I don't think that's the only area of patent law where there's a heck of a lot of ambiguity, some of which may be inevitable, but some of which could probably be addressed if people really wanted to. So that's one point, but then maybe the second point is just the fact that this National Court of Appeals never got off the ground. May just, despite the fact the only opposition seems to be some cranky judges, at least in your telling, suggest that maybe there wasn't really enough of a business interest in actually pursuing that, because maybe businesses don't actually really care whether there's uncertainty. Now, you could respond, well, we did get the federal circuit. On the other hand, maybe that really is because people thought the federal circuit would be substantively different from, let's say, the average courts of appeals would end up more like, I guess, it was the Fifth and Seventh Circuit in John's telling, than like the other circuits. I don't know if that's the correct story or not, but it seems to be plausible that no one really cares about uniformity. They really care about whether they get their own point of view in there. Now, today, when we start talking about National Court of Appeals, I think that the first lens through which people would see that is, well, does this affect the power of the Supreme Court? And so predictably today, I think you'd have conservatives who oppose and liberals who favor, depending on who the president is at any given time, but right now, and if things switched around and we had a liberal Supreme Court and a conservative president, then everybody would magically switch their positions and pretend that they've been consistent all along. So I do wonder whether whether uniformity is overrated, at least in terms of how much people care about it in the business community, and B, whether we could really adopt this sort of kind of progressive, I think, the 100-year-old definition of progressive vision of making the law more scientific in an era in which everyone is hyper-partisan.
So great description. I think you're right that some people who favored the creation of the federal circuit saw it more about getting specialist expertise, and as you said, people that might favor their viewpoint, than about getting uniformity. Of course, all things that change in politics are from political compromise. It's a happenstance of what needs happen to exist at the time that a particular proposal exists. And it just so happened that at that time when the federal circuit was proposed, that there was this pressure from the presidential administrations to say, let's unify patent law so that we could become more powerful on the international stage for innovation. I think that was one of the biggest drivers.
Yeah, it was part of a big 20-point plan, and this is just one little point of it.
Exactly. And it's funny, when I looked back at Professor Meador's letters when he was originally suggesting creation of the federal circuit, there's no mention of patents in those original letters. He focuses on environmental and tax and then says, and maybe science. This originally was not about creating some specialty in patent law, but it developed that way because of political interests. And we saw that the patent bar got very on board with this idea of creating a specialized court, perhaps because they saw a desire to influence it. When you have some groups that favor it for that reason, and some groups like the presidential administrations that favor it for improving competition and innovation, you end up getting the proposal passed. So how that relates to today, we'll have to see how the politics line up. I think you're right that the only way to get something like this passed, even if it's the right idea, and I think it is to hit it at a time point when there's political alignment to do this. I think that it's hard to figure out exactly what sorts of happenstances might arise that could spark that political fire. My proposal is just that this is the right thing to do. And how that politically gets passed, I think I have to wait for some accident to spark the fire of interest there, to say we have multiple groups that align for different reasons, whether that's to get rid of the insularity at the federal circuit, whether that's perhaps the the biopharma community concerned about 101 case law or anything like that. We just have to wait for those interests to align. But I think the proposal here is about saying this is the right thing to do. And hopefully eventually we get the politics to line up with that.
We have a question that from Zoom from Professor Esther von Zimmern. She says, thank you for a very interesting lecture. I'm a professor in patent law in Europe. Is your proposal especially aimed at the federal circuit as a specialized patent court, or is it also relevant for specialized patent IP courts outside of the US? Lately, we have seen a global trend towards more specialized patent courts. See, for instance, the Unified Patent Court in Europe, but also in many other jurisdictions. And partly I wanted to ask this because it tags on the question that I have had, which is that, I mean, this is very interesting to me. I think this is persuasive, but I wanted you to reflect on the idea that this is kind of the opposite of how specialized patent courts work in most other jurisdictions, or could be at the trial level, at the fact-finding level. I mean, never mind the whole jury issue, but to have the specialist at the lower trial level and then have the appeals court be the generalist just makes more sense on so many levels. And I thought these kind of two questions.
I agree with you 100%. And I do think that this could be paired with proposals, which I'm actually addressing in one of my upcoming papers as well, to create a pilot program to have more specialized technical expertise at the district court level. I do think that's an important way to get scientific expertise, because many of those complex scientific decisions are made at the trial level, especially when it comes to how do you interpret an expert saying this or an expert saying that. Now, most district court judges work very hard to get up to speed and really do end up coming to understand the technology very deeply by the end of their case. But I do think that having some level of technical expertise could aid them in that. And coming back to the question asked on the chat about how this applies on the international stage, yes, I think we should be cautious about how we are structuring courts in all countries. Many countries have seen the federal circuit as a success because of the way that it impacted the United States' position for innovation, as those presidential administrations wanted it to do. And so many countries are copying the federal circuit system, or I shouldn't say copying, but focused on having more specialist courts with this idea that perhaps this will help with innovation in their country. I think this should be a cautionary tale, that perhaps after 40 years, that might not be something that's beneficial in that country, but it will depend upon all those other factors that we looked at. It will depend on how active is that final Supreme Court in addressing those decisions. How much conflict is there between the Supreme Court in that country and the specialist court? Does the Supreme Court trust and respect and follow that decision of the specialist court? If so, maybe it doesn't create the same problems for uncertainty as it does here, where we have that level of distrust and that conflict. So it might be different, but I do think it's a cautionary tale.
Unfortunately, we are out of time. There are more questions online and in the room, but we need to let the students go. So thank you so much.
Before you go, I just want to thank Professor Laser for coming. She flew in the snow last night, right, yesterday afternoon. So if you're watching the football games out in Cincinnati, she was probably dealing with the same weather, or I guess in Buffalo. And our next talk will be on, I think it's Wednesday, March 1st, which is the Wednesday before break. So please come. It's obviously more fun with more speakers. She'll be up here for a little bit if you want to come and ask her a question. The last thing I'll say is you may read papers like this and say, oh, this will never happen today. And I think she probably agrees. But when did Professor Metter, I think that's how you pronounce it, that's how I heard it, he was from UVA, who was blind, I believe, he was a pretty interesting guy. When did he first propose this court?
So
And how long did it take for it eventually to be adopted? Probably a decade.
yeah, I was about a decade.
So that's why people plant the seeds and they create this discussion. So maybe someday, just like he eventually, some form of what he proposed eventually got adopted. That's why people did it. So let's give her a big hand.
Yeah, I welcome your questions. Anyone to come up. I remember that was very valuable to me when I was a student. So please come talk to me.
You have a question here.
Yeah. Absolutely.
How much of this time like this we get, how many cases are-
Yeah, so to answer, I don't know if you can hear me, but for the recording, I think it does depend on this idea that patent cases are not fundamentally different from other complex areas of law. And if you have a complex question of tax law, or even a complex question of the DNA evidence in a criminal case, that's something that technical expertise is beneficial in, but ultimately our court system is designed around generalist judges and the generalist Supreme Court. So we're going to need to not have this patent exception.
Well.
Thank you for coming. So good to see you. Yes.
Oh, yeah, we did. Give them all that.